Hmm. Well, the CFPB, which is Consumer Finance Protection Bureau, had sued some student loan trusts, 15 student loan trusts, alleging that that the servicing of the student loans was improper in various ways. And the student loan trust said, okay, we've got servicers, and you could sue them, but you can't sue us. And the CFPB said, yes, we can, because you are what's called a covered person under the statute, and we are allowed to sue covered people. But the biggest question had to do with this question of this issue of whether or not securitization trusts, which are brain dead legal entities with no employees, no operations or anything like that, and so the Third Circuit found that they are covered people, and therefore the CFPB has jurisdiction over them, and so the case could go forward. So then it was appealed to the Supreme Court, and the Supreme Court denied review, and so the case stays as it is, and goes back to the Third Circuit.
So a bit of a Hail Mary. And as you said, not a surprise that the Supreme Court it didn't want to take a closer look at this point in time. Could take a look if there's conflict among the circuits at a future date. So we're left with this decision that erodes essentially the bankruptcy remoteness, or I refer to it as a moat of insulation between litigants and the assets that support the securitizations, the securities that are backed by those assets and held by the trust.
Right. Yes. Yes. It's a moat around the trust, which is accomplished by the trust having no employees, no operations, no nothing. They'd say bare legal entity. If you think about it, suppose you have. I don't know. You've got an infant daughter, okay, and you set up a trust for her, okay, and you hire a trustee. I don't know, Goldman Sachs or somebody to invest this money. Okay. Well, and this then comes to your daughter when she reaches maturity. Okay. Is that entity involved in the business of, say, brokering securities or something like that? It is a passive owner, but it is not itself a legal entity that can be sued. If Goldman Sachs does something wrong, it's not liable to be sued there. It's just a purely passive thing. I mean, it's a nominal entity. It is a legal person, but under in the barest sense of the word. So that creates a moat. Everybody has always thought that protected the assets. If there is wrongdoing, of course, the companies who are engaged to service or perform services as trustee or whatever it is, they are obviously going to be liable. They're operating companies. They should be sued, can be sued if they behave badly. Absolutely, no question about it. The only question is whether or not the trust itself is also liable, along with the servicer for the things that the servicer has done.
Right.